Now, we could argue...
I totally remain confused, okay? The core of the right to control theory is that a prosecution is allowed to show a deprivation of property simply by showing a deprivation of economically valuable information. You've disavowed that, correct?
Your Honor, I read simply that broadly, yes.
All right, but that's how the Second Circuit has read it, and you are not defending that, correct?
We're not defending, if I could just be clear on what we're defending and what we're not.
Just answer my questions, okay? Because are you defending the Second Circuit's view that a deprivation of economically valuable information is enough to prove fraud?
Your Honor, if the definition started and stopped there, we do think that is an overbroad definition of property fraud.
Okay. So you're saying that definition by the Second Circuit you're not defending?
We are not defending that in all of its possible permutations. What we are defending here is how that has been applied and limited by the Second Circuit, in particular with its tangible harm requirement and by its application in the context of fraudulent inducement cases like this one, where there is...
The charge here was, I'm reading directly from the charge, the victim's right to control the use of his assets is injured when it is deprived of potentially valuable economic information that it would consider valuable in deciding how to use its assets. Is that an accurate statement of the law?
Your Honor, I think in the context of this...
Don't give me a context.
Okay,
is that an accurate statement of the law?
That is not how we would... first of all, it did go on to talk about the tangible harm requirement.
It says potentially valuable economic... I'm reading the charge. Information is how to use its assets, is information that affects the victim's assessment of the benefits or burdens of a transaction, or relates to the quality of goods or services received or the economic risks of the transaction. Is that an accurate statement of the law? This is a jury charge.
Your Honor, I think if you're taking some of these statements in isolation, I agree with you. I acknowledge to this court, I believe I've been acknowledging throughout, that is not the way that we would formulate it. If you're asking me instead whether we think it can identify cases that do meet the paradigm of property fraud, and if you're asking me whether I think the jury could have convicted without finding traditional property fraud, then I'm going to defend both the instructions and the conviction. If you're asking me whether we would think that this is the kind of first principles right way to articulate it, I'm going to agree with Your Honor that the answer is no. I think really there are two main points I just want to emphasize here. One is that I do not think the court should cast any doubt on pedigree fraud or relitigate whether there's some harm requirement for property fraud generally. And then in the specific context of this case, I think if the court wants to do anything other than affirm, it should remand and let the Second Circuit sort out where we might be now. But if we do think that this conviction can be affirmed because the findings under the right to control theory do map onto property fraud in this context, because there were no other assets we could be thinking about other than the $750 million.
But Mr.